Good afternoon. My name is Christof Karl, and incidentally, I'm from the same law firm as the previous speaker, Stefan Steinbrenner. I'm a partner of Bardehle Pagenberg. I'm doing patent litigation and prosecution primarily in the field of IT. And I will talk about the very same subject as my colleague did, but from the German perspective. So you may ask yourself, after we heard the presentation about how can we patent software patents in the EPO, why would you care about Germany, since you can get a patent for Germany also via the EPO route? Well, despite there being the European Patent Office, there's still a significant number of national applications in Europe. So the EPO has roughly 150,000 patent applications a year. The German Patent Office has about 60,000 applications a year. Why do we still have national applications in Europe if you can have a European patent? The answer is primarily costs. The European patent is more expensive to prosecute. The fees are much higher at the EPO. And it can be said that if one wants protection in only 1, 2, or 3 countries, probably the national route is less expensive than the EPO route. And I can tell you, for example, IBM, a big player in the IT field and certainly a big patent filer, files only national applications in Europe. They do not go via EPO. There may be a renaissance of national applications also with the new unified patent court, which is likely to come. Nobody knows how patentee-friendly the new court will be if it comes. There will be a transition period of 7 years during which the jurisdiction of the unified patent court is not exclusive, so patent owners can opt out and they can continue to use the national courts if they think that the national courts are more patentee friendly. But after these 7 years, any applicant of an EP patent will have to litigate their patents with the Unified Patent Court and cannot use the national courts, for example, the German courts anymore. So if applicants want to continue to use the national courts after the transitional periods, they will have to file national applications. And it remains to be seen whether the number of national applications increases after that period. So there's actually 2 ways to get a national patent in Germany. One is you file your application with the German Patent Office. You have the prosecution proceedings with the German Patent Office, and the German Patent Office grants a German patent. But you can also go via the EPO route. You file an EP application, not of course only for Germany, it's for all member states then. You have the prosecution proceedings before the EPO, and the EPO then grants a European patent. But as you probably know, there is no European patent really. There is only a bundle of national patents. So we have one single examination procedure, but what the outcome of this examination procedure is national patents. And these national patents are then enforced in exactly the same way as national patents which have been originally applied for example, in the German Patent Office. So A second reason why German case law in the field is also important, and not only EPO, is that during litigation, the validity of the patent, may it be granted by the German Patent Office or by the EPO, is looked at by the German national courts if this litigation is taking place in Germany. And currently, since we do not have the Unified Patent Court yet, Germany is in most cases the country of choice for litigation. About 60% of all patent litigation in Europe is going on in Germany. For example, of the list of Raj, which you saw previously here on the board, all of these cases were also litigated or are still being litigated in Germany. So in case a patent which was originally granted by the EPO is enforced in Germany, the German court will apply its rules and not the EPO rules to whether the software patent is actually valid or not. The German national law is very much harmonized with the EPC with respect to computer-implemented inventions. Like my colleague Stefan Steinbrenner said, there's a technicality requirement, that is patentable subject matter is only what is technical. We also have this little strange provision which says that only computer programs as such are excluded from patentability. Nobody really knows what a program as such is, but the case law says a computer program as such is one that does not have technicality. A little bit of history. Stefan Steinbrenner said before, we do not know what technicality really is. What is technical? It's kind of like pornography. It's hard to define, but you know it when you see it. But the Germans, they tried to have a bright line definition of what is technical. Excuse me, that is actually the next slide. And the definition we had in the 80s and in the 90s was that it is technical teaching is to methodically utilize controllable natural forces to achieve a causal, perceivable result. This definition turned out to be too narrow with the new technologies which arrived in the 90s and later on. So this definition was abandoned. It was funnily cited by the EPO in its G3 decision in 2008, but it has been overruled for a long time in Germany. This definition was part of the reason why in the 80s and early 90s it was very difficult to get a software patent granted in Germany. From the middle of the 90s on and until now, the German Federal Court of Justice, which is the highest court to rule on patents, took a more liberal approach and more got in line with the EPO case law. Especially the requirement of technicality, which, as Stefan Steinbrenner said, is a very low hurdle to overcome in the EPO, is now treated the same way in Germany. So something is technical if, for example, there's the word computer in the claim. It is sufficient to mention the word computer and you overcome the first hurdle of technical subject matter. However, there is the second step of inventive step. And during the inventive step analysis, only those features are taken into account which contribute to a technical to overcome a technical problem, to provide a technical solution. So just by putting the word computer into the claim, you will overcome the first step of, do we basically deal with technical subject matter, but you will not overcome the second step of inventive step, because if a computer is a well-known thing, so this will probably not be a point of novelty or a point of inventive step. So in the inventive step analysis, what is new and novel and inventive must actually be technical. Also in this respect, the German case law is in line now with the EPO approach. However, while in Europe we have only two steps to the analysis, the first one being, is there technical character at all? And the second step being, do the features which are supposed to be novel and inventive, are they technical? We have a step in between in Germany, and that is the question, is there a solution to a concrete technical problem with technical means? So this is what differentiates the case law in Germany from the case law in the EPO. And there's a solution to a concrete technical problem with technical means if, and now our case law provides three alternatives, device components are modified or addressed in a novel and fundamentally different way, or the computer program is determined by technical aspects which are external to the data processing equipment. For example, if the computer is controlling another device, let's say a medical apparatus, and the medical apparatus is clearly technical, so is then the computer program claim. The third alternative, the computer program takes account of the internal conditions of the data processing equipment, for example, of the architecture of the computer hardware to make it run more efficiently. There are a couple of open questions today. For example, we do not know whether this list, which I just presented, is an exhaustive list, or if other points can also justify that there's a solution to a concrete technical problem. We do not know whether the device components in the first point, device components are modified or addressed, have to be hardware components. That would be a very limited approach then, or can it also be software components? And we do not know whether for the determination of the concrete technical problem, the prior art has to be taken into account or not. So do we look at the claim and what is specified in the description, or do we have to perform a prior art search, determine the differences over the prior art, and then determine what is the problem that is solved by the differences? All this is unclear to date. Another difference between the German case law of our highest court and the EPO is that the German courts are somewhat adverse to means of data processing. For example, the most recent decision, which from the point of view of patent prosecutor in the field of software programs was a very unfortunate decision, said that steps like compiling, processing, storing, or transmitting data cannot contribute to the solution of a technical problem by technical means. So obviously many software patent claims will only consist of such steps, the EPO, but there are some fluctuations which are somewhat irritating. So we're not quite there yet, but hopefully we will be in line with the EPO very soon. The last part of my presentation is about the effects that the case law of the Federal Court of Justice has in the lower court, which is the Federal Patent Court, and in the practice of the German Patent Office. Since not all of you will be familiar with this, I give you an overview of how the Federal Patent Court comes into play here and what is the role of the German Patent Office. So if there's a German national patent application, obviously the German Patent Office does search and examination and either grants the patent or refuses the patent. So this is where the German Patent Office, where the practice of the German Patent Office matters. If the patent is granted, there may also be an opposition, and the opposition proceedings are also handled within the Patent Office, and this again is where the practice of the German Patent Office matters. So in the first instance of the granting proceedings, it's all done in the Patent Office. Where does the Federal Patent Court where's the Federal Patent Court involved? Well, in all appeals from decisions of the German Patent Office, and it may be an appeal which the patent owner files because his application was refused by the Patent Office, or it may be an appeal by either the patent owner or the opponent to an opposition decision. So this is where the Federal Patent Court is involved in the prosecution phase. And there is sometimes a second appeal to our highest court, the Federal Court of Justice, but this appeal is not an appeal of right. Only very few cases on the prosecution route do end up with the Federal Court of Justice, because only those cases can go up which are allowed to go up by the Federal Patent Court. The Federal Court of Justice normally is not involved in the prosecution. However, the Federal Court of Justice, our highest court, is heavily involved in litigation proceedings. So there's a German national patent or the German part of a European patent being litigated in Germany. And as you may know, in Germany we have the bifurcated system, so the district courts look at the question of infringement, whereas only the Federal Patent Court will look at the question of validity. And the Federal Patent Court only does so if the defendant of the infringement action files an invalidity action. This invalidity action is filed with the Federal Patent Court, the same court which is the appeal instance in the prosecution route. The outcome of the invalidity action may be that the patent is maintained or that the patent is invalidated or invalidated in part. And this decision can always be appealed to the Federal Court of Justice, and this appeal is an appeal of right. So on this route, all parties have the possibility to go to the Federal Court of Justice, to the highest court, and this is the vast majority of cases where the Federal Court of Justice raises its voice about patentability. It's not so much in prosecution route, it's much more in the litigation route. Now, why do I tell you all this? It's because the practice of the Federal Patent Court, unfortunately, for patent owners is more restrictive when it comes to allowing software patents. In fact, the more liberal approach taken by our highest court recently, the Federal Patent Court, was very reluctant to follow this line of cases, and only did so if it was compelled to do so by the Federal Court of Justice. In particular, the Federal Patent Court is very reluctant to find the patent valid or the subject matter to be patentable in cases involving data processing. That is the steps which I mentioned before, so compiling data, sending data, receiving data, etc. Another field where the Federal Patent Court is very restrictive is aiming at improving ergonomics of user interfaces. For example, the Apple smartphone litigations which we're having in Germany, you know, Apple does not have patents on the protocols like GSM or UMTS. What Apple has is patents on the user interface. And so one patent that is being litigated right now in Germany is the famous slide to unlock mechanism, which probably most of you know. So to unlock the phone, you slide a slider from here to there. The question is, this is a patent that was granted by the EPO. There was no question that this is patentable subject matter in the EPO. The question is, will the Federal Patent Court be of the same opinion? Remains to be seen. And the third area where the Federal Patent Court is much more restrictive than the EPO is computer-implemented inventions involving improved mathematical methods. For example, you have a medical device like a computer tomography machine where the hardware is exactly the same as in the prior art, but the difference is in an improved algorithm for processing the images that are taken with the machine. This algorithm applies different mathematics than maybe the prior art algorithm. In this case, the Federal Patent Court tends to only look at the differences, say the differences lie in a new mathematical algorithm, which is not a field of technology and therefore not patentable. I'm almost at the end. This is actually my last slide, or my second last slide. What is the consequences for the user if a patent applicant wants to have a patent in Germany, especially in one of these three fields, so involving data processing, involving the ergonomics of user interfaces, and involving improved mathematical methods? I unfortunately cannot recommend to go to the German Patent Office. I forgot to mention that German Patent Office follows more the case law of the Federal Patent Court rather than the case law of our highest court, so also rather restrictive in this field. So for prosecution in these fields, I cannot recommend to go to the German Patent Office. I rather recommend to go to the EPO, try to get a patent in Germany through the EPO route. When it comes to enforcing the patent in Germany, you may ask, what good is it to have a patent in Germany through the EPO route if it is then invalidated because Germany takes a more narrow approach also in litigation? There, the good news is that because you have access to the highest court, which has a more liberal case law, and you're not stuck with the Federal Patent Court, the chances of success are much higher than in prosecution. So please continue to come to Germany and enforce your patents in Germany. Thank you very much.